It's really a privilege to give this presentation. I've given it a number of times to audiences in different settings. I suspect that most of the people listening in today are retired people. They're no longer working. So this topic will be mainly of intellectual interest. However, many of you during your working days may have encountered some of this workplace harassment or bullying. I use the terms interchangeably. And also, and just as important, you may have sons or daughters, nieces or nephews who may be witnessing or going through some of this, some of these activities on the job, and you may want to pass on some of this information to them. I'm going to be talking about the legal developments in terms of harassment and bullying in the workplace, starting mainly with the Civil Rights Act of 1964. But before we do that, in order to appreciate how far we've come, I wanted to tell you what life was like prior to the Civil Rights Act of 1964, back in the 50s and early 60s, where there were no federal regulations or laws dealing with employment in the private sector. The private sector as opposed to the public sector. It was pretty much the Wild West. Employers could discriminate with impunity in terms of who they wanted to populate their workforce. They didn't have to hire African Americans or women or older people or even Jews. I mean, it's commonplace knowledge that even in Cincinnati, up until the 60s and maybe even past that, law firms would be very open in their claims that they were looking for Christian, more particularly Protestant lawyers. A lot of firms wouldn't hire Catholic lawyers. Some firms ended up being known as the Catholic law firm or the Jewish law firm because they couldn't get jobs anywhere else. Want ads were targeted. It's hard to believe today, looking back to the early years, you open up the Washington Post of all newspapers, and they would have ads for women and other want ads for men. And there were also African American sections and white sections of the classified ads. And when I talked to my kids about this, they were laughing. And I said, I know it sounds crazy, but that's what it was. I saw ads, wanted good Christian man to be a bookkeeper or a CPA. And at the time, no one made a big deal about it because that's the way it was. Turning to the issue at hand today of harassment or bullying, it was wide open. You had a Mad Men type of work environment where men looked upon secretaries. I'm generalizing, obviously not every workplace was like this, but I remember being in a law firm as an office boy in Washington, D.C. in the very early 60s. And there was a lot of, catcalling going on and double entendre references to women. I didn't see anything really, really blatant, but there was a lot of low wattage kind of remarks. But there were other places, not just law firms, obviously, where women were taken advantage of sexually, and a lot of women seemingly went along with it. They were smiling when they went out with their boss for lunch or dinner, and one can only wonder whether they were smiling on the inside, but that's the way it was. Obviously, Mad Men is somewhat of an exaggeration, but not too much of an exaggeration of what was going on. Well, all that changed and I always call it the heyday of liberalism, the 1960s. President Kennedy had died, leaving an unfulfilled legacy that he had wanted a Civil Rights Act. It didn't have the intimate knowledge of Congress to make it happen, whereas Lyndon Johnson did. And and that's a talk in and of itself of how he was able to get the Civil Rights Act passed. But it was passed in 1964, ostensibly to end discrimination based on race, because that was the main issue of the day. Sex, curiously enough, was added to the statute as a prohibited form of discrimination in a backhanded kind of way. Some Southern congressmen and senators said, let's stick sex in there too. Nobody will want to go along with that. Come on, no one believes that women have the same rights. And they thought it would backfire against the legislation and people would vote the whole thing down. But that didn't happen. Sex ended up being a category of protected status. Not much was made of it at the time. It kind of crept in there ultimately by default because of this attempt by the conservative Congress people. But in any event, it came in there. And it also just obviously prohibited discrimination based on religion and national origin. But again, the main focus was race. And a couple of years later, there was an age discrimination law passed, which prohibited discrimination based on race, i.e. people over 40 years of age. It's important to note, and people overlook this, but for the first 20 years or so of this law's existence, the focus was on discrimination only, not harassment. So all of the cases that came before the courts dealt with discrimination, like I wasn't hired because I was a woman, or I was fired because I was black. It had to do with a change in someone's actual job status, be it a failure to hire, a termination, a demotion, a transfer, and it all had to do with discrimination. Harassment was never really an issue. That changed. You can scroll down a little bit. I guess we're on page 2 now, Sam, Rabbi. On page 2. That changed in a case called Meritor Savings Bank versus Vinson in 1986, where the Supreme Court ruled for the very first time that workplace harassment on the basis of sex was a form of sex discrimination, even if there were no tangible adverse job consequences like a termination or a demotion. Pure harassment, just for the sake of harassment, was now deemed to be in violation of the Civil Rights Act, even though the person never kept her job, was never any money involved. And this was a revolutionary change. And the key phrase here was, the question the courts would look at was, did this conduct interfere with the individual's ability to do her job effectively? And obviously, if someone is harassed sexually, either verbally or worse, physically, most plaintiffs could show that had an effect on their ability to do their job. They were less enthusiastic. They were more paranoid every day they went to work. They may have had mood spells, whatever. It was not that easy for them to do their job. And there have been countless cases entering into the stream of litigation since 1986. And I've been involved in a number of those cases, primarily representing women. Although the court didn't say it in 1986, the same logic would apply to other kinds of harassment based on things other than sex, such as race or age. Age discrimination or age harassment is not all that prevalent, but race harassment is. Leaving a noose on someone's chair, making watermelon comments about someone. That could be racial harassment. About 10 years later, the court advanced the law even further in a case called On-Cale versus Sundowner Offshore Services, another landmark case. This time, the court held for the first time that you could have workplace harassment by male employees against other male employees. Now, some people would say, oh, wait a minute, that's not sexual discrimination. That's only when men harass women or vice versa. But the court said, and this case involved one of those oil drilling platforms in the Gulf of Mexico where a lot of guys were together for long periods of time, and they would pick on each other. Well, one of the guys they picked on was a male coworker who they perceived as effeminate, whatever that means. Talk with a lisp, talk with a high voice. There's no intimation that this individual was actually gay. He just was effeminate. And the court said that was discrimination based on sex, because had that coworker been a woman who acted as a woman would act in terms of her voice or whatever, that may not have happened. But they were picking on him because he didn't fulfill the standards of a typical alpha male individual, and therefore that was deemed harassment based on sex, which again now laid the groundwork for a real blockbuster decision that just came out in June of this year, Bostock versus Clayton County, Georgia, where the Supreme Court extended the on-cale rationale to actual gay, lesbian, bisexual, LGBTQ, I never figure out the right way it said, LGBTQ, harassment. And this case involved actually a series of 5 cases which were consolidated by the Supreme Court, all of which involved harassment and discrimination against people who were either lesbian, gay, transgender, or whatever. And the court held, and this was really important, this was a 6-3 majority. Even 2 of the conservative justices, one of which was, I believe, a Trump appointee, maybe not, I'm not sure Gorsuch was, I think he was a Trump appointee. Gorsuch wrote the majority opinion and said that gay employees were protected against discrimination and harassment. And the interesting thing about this case, it was not like he was saying there was something inherently protectable amongst gay employees. He was not talking about how important gay employees were to American industry and it was unfair to be anti-gay. He took a very narrow, but as it turned out, decisive position that discriminating against gay people is nothing more or less than actual discrimination based on sex. And he said if a bunch of male employees work with a woman who likes to date men, they don't get harassed because they're acting the way women generally act. But if a male employees or a male boss doesn't like a male employee who also likes to date men, that's harassment based on his gender, because he's the same as the woman. They both like to date men, but the man somehow is more susceptible to harassment because he likes men. And Judge Gorsuch says that is strictly discrimination based on the status of the target of the harassee or the target of the bullying. He's a man. So that was a remarkable decision, especially coming from someone from Gorsuch's position on the ideological spectrum. So we now have a situation where it is, at least the Supreme Court has said, that you cannot discriminate or harass gay employees. Now, there is a footnote to all of this. He said that there is maybe an issue of whether an employer can discriminate against gay people based on religious considerations, religious freedom. But he said that's not before us today. So the door, I think, is kind of open. This is something, you can have a big discussion on whether an employer can say, well, I find people who are gay or engaged in sinful conduct forbidden by the Bible, and I don't want to have to hire them, or worse yet, cover their spouses who are living in sin. We're not there yet. We're not there yet, so we don't know where that's going to go, but that door is still open. So that's basically the legal landscape we find ourselves in right now. So I want to turn my attention to now the practical impact on employees who find themselves being bullied or harassed based on any one of these categories: race, sex, national origin, or sexual preference and orientation. Obviously there's damages that are suffered by employees that they can seek recourse in either in federal or state court. Obviously some of the damages are in the form of lost wages and benefits if an employee quits or is fired for refusing to give in to a boss's or coworker's demands. And that's a clear, case of hard damages. How much money has he lost or she lost in wages, and should the employee be reinstated, and if so, how much is that employee owed in back pay? That's kind of a arithmetic kind of damages that you can figure out. There's fallout to the morale of the entire office if basically they are not happy with what they've seen happen to their coworker, because they may be intimidated into not protesting for fear they may end up in the same position. But the main big ticket item in damages for people who are unlawfully bullied or harassed in the workplace is emotional distress damages. We've all heard of emotional distress damages. They are part and parcel of any damages in what we call tort law, where the defendant has failed in a duty to protect an individual, in this case an employee. And emotional distress damages can run the gamut of someone who's just mildly ticked off and unhappy but finds another job right away, or has a strong emotional constitution that person's not all that unhappy or upset at what happened. But by and large, most people, as I've seen them, have emotional distress damages. If the harassment and bullying has taken physical dimensions, the emotional issues or the distresses is intuitive, it's obvious. Even just verbal harassment can be devastating to people. If they're fired, sometimes their spouses think that they were asking for it, that, I'll use a female employee, but it clearly can apply the other way too. But the female employee is forced to have sex or engage in other foreplay kinds of things with her boss. It leaves a lingering sense of distrust with her spouse. Sometimes she takes it out on her children when she comes home. Every case is different. The courts allow even the aggrieved spouse to file a claim for loss of consortium, which is one of the Latin words, which means that the spouse has damages too, based on his wife's emotional upset and not wanting to even engage in intercourse with her spouse. The issue was even worse for lower paid employees or single parents, because they need that job. They need that job more than someone else might. I mean, for people here I'm talking to today when you were working, you may have said, to hell with this, I'm out of here, I'm going to look for another job. But for a lot of people, they need the medical benefits. A single mother, a waitress, someone works at McDonald's or something like that. It's not that easy for them just to quit. They should. And it's funny, whenever someone comes to me for an initial consult, I always tell them, I say, you have all the legal rights in the world, but your health comes before anything else in the whole wide world. If you're dying inside or you're devastated, you have to quit. I mean, I know it may sound like less heroic advice, but I would think most people here would admit that you can't go on and do harm to yourself. I mean, there are physical byproducts of an emotional distress. You can quit and then turn around and sue the employer for wrongful termination anyway, under the doctrine of constructive termination, which means that you can argue that no self-respecting employee should be expected to put up with this kind of harassment or bullying, and I'm going to quit and then turn around and sue you anyway. And the employer can say, well, you quit, I didn't fire you. And she can come back and say, well, you made it so, you knew what you were doing, you made it so impossible for me to work, I had no choice. So there's a lot of litigation in that area as well. So from a pragmatic standpoint, what can one do to protect yourself short of filing a lawsuit? Because the lawsuits are always the last resort. It means everything else has failed. The first thing you can do is, if you work, not you in particular, but anyone who's in an employment situation, first thing you do is, if you work for a company of any size, they generally have an employee handbook. And the employee handbook has language in it. It should have language in it. The employer is crazy if it doesn't, to say that if you feel you've been harassed or sexually abused or bullied or racially abused or whatever, there's a hotline procedure that says you can immediately bypass your supervisor, who may have been implicated in the whole thing from the first place, and file a complaint with some neutral, preferably a woman, some neutral person in HR who will take your complaint and keep it confidential and be very sensitive, and will investigate it from the ground up and look into your allegations. And if you have witnesses, we'd be more than happy to talk to your witnesses. It's very important that you do this, or employee do this, because number one, hopefully it'll solve the problem. And many times it does. And if it doesn't, and then you have to go further, you can at least say later on, look, I followed the chain of command, I did what I had to do, and they still didn't fix the problem, and it got worse. That way you give yourself more of a credible case. If you go into court in front of a jury, you can say you didn't put up with it, you did whatever you had to fix the problem. Again, a lot of times these cases are successfully resolved in HR because the perpetrator oftentimes just doesn't get it. He may have said something which is off color, even persistently, because he didn't think it was a big deal, and HR can straighten them out right away, and the case is solved with little fanfare. But oftentimes, as I said earlier, it isn't. And when it isn't, then you have to start thinking about whether you actually want to go to court. And again, going to court is never a picnic. It's never a day at the beach. It's a very, very stressful situation, but you may have no other choice. When you go to court, you have two choices. You can go to federal court, which administers federal laws like the Civil Rights Act, adjudicates them, or you can go to state court, because Ohio has a law very similar to the Civil Rights Act. It also, Ohio prohibits harassment and discrimination. If you go to federal court, you can't just run to federal court right away. You have to first file with the EEOC. which is the Equal Employment Opportunity Commission. They have an office in the federal building. They have to file a charge and give the EEOC a chance to investigate your claims, make findings, and maybe mediate a settlement. If that doesn't work, or they're dragging their feet too long and you're tired of waiting for them to do something, you can then ask the EEOC to give you something called a notice of right to sue, which then allows you to file a lawsuit in federal court. And there's a federal court sitting right here in downtown Cincinnati, District Court for the Southern District of Ohio. It's right on Government Square where all the buses stop. That's a federal court. You get a jury trial. The judge is generally a very, very knowledgeable individual. He or she generally has a very good pedigreed law background, is well recommended by the American Bar Association. And the judge, this is very important, is appointed for life. For life, which means that the judge doesn't have to worry about popular opinion or getting elected every 5 or 6 years, whatever. And that's a good thing. Although some judges are by nature very conservative, pro-business, other judges are more liberal and tend to lean more towards sympathizing or empathizing with the employee, but they still have to follow the law. The damages include what you might expect: back pay and benefits and reinstatement, or if reinstatement is not practical, and for middle-level management people who become plaintiffs, you never want to go back to the company that treated you the way it did. So the courts recognize that and say, okay, we'll give you not only back pay, we'll give you front pay into the future for a reasonable period of time. You can also sue for pain and suffering damages, and you also get your attorney's fees and costs if you win. If you go to state court, and the state court is right there on Court Street, at the end of Court Street, you know where that is, on Main and Court. You get a jury trial, just like you do in federal court. But here the judge is elected. Judge is elected every, I should know, but I don't know this. I think every 5 or 6 years. Elected judges are, try real hard to reach a decision irrespective of how it will look in the public opinion. But some, it's when you're elected, you got some judges think about that, and especially when you have cases against big companies like Procter & Gamble or Western Southern or Kroger, you always have to worry about whether the judge wants to make a decision against one of those companies. I'm not saying they would, but any elected judge, that's inherent in the system, that some judges are always worried about the next election. You get the same damages in federal court, except you can't get attorney's fees as a matter of right in state court as you can in federal court. But one thing you can get in state court that you cannot get in federal court is you can sue the perpetrator of the harassment or the bullying, as well as the company itself. And that may be significant if the perpetrator is a high-up person in the company with deep pockets. So it sounds good, obviously, that there is recourse, and many times plaintiffs, and you've read about it in the paper, plaintiffs win these cases, and those are the success stories. But I don't want to sound too pessimistic, but I call that an obstacle course, and I've seen it in action because I've represented many employees, and many employees somehow they go through all these hurdles during litigation, and some of them are very hard to surmount. And I'm going to run through some of these hurdles because this is a real life issue when a plaintiff is in court for bullying, protesting bullying in the workplace. The first one is, as I told you earlier, if the plaintiff never complained about harassment to anyone or didn't follow the prescribed chain of command or the hotline procedure, the employer is going to argue, well, why didn't you complain? You didn't complain either because it didn't happen or you liked it. You were having fun. And there may be many reasons why the employee didn't complain. Maybe she was afraid. Again, maybe she's a single mom or whatever and doesn't want to rock the boat. But that's a real hurdle. That oftentimes is fatal to your case. Another one, and you see this a lot, the offensive conduct was not all that big of a deal. It was isolated, ambiguous, or it didn't happen at all. And the courts sometimes recognize this. If you're a female employee and a male employee makes a remark about your tight-fitting sweater, that's offensive. And it's unfortunate and it may be unprofessional, but you're not going to get very far with things like that if they happen every now and then, maybe once every other month. A lot of courts are just going to say that's just not egregious enough. It's just not aggravated enough. The courts are not here to act as nursemaids for employees who are offended by minimal, jovial kind of remarks. I've seen this happen once. I had a jury trial verdict taken away from me for $250,000. I'm not going to mention the company, obviously, but the employee was a fairly attractive woman, and she was always, they made fun of her physique, her legs, her breasts, and all that, calling her all kinds of names, hot lips and all that kind of stuff. She went to the general counsel for the company and complained about it. The general counsel was a woman, and the general counsel said, honey, that's the way these men are. You just have to learn to live with it. I thought we had a great case. And again, we won in front of a jury, but the Sixth Circuit Court of Appeals, the major appeals court in Cincinnati, reversed it, saying that, this is life in the 1990s or early 2000s. There's sex charge advertisements on billboards. There are sexually charged TV shows like Baywatch and all that. You got to just learn to live with it. And I was shocked because the jury thought that she had suffered. But this is another one of the things you have to, a victim has to confront. Another one is the employee was asking for it. What I mean by that is that the employee said, oh, she was wearing a low-cut dress, or she was wearing a mini dress. She had provocative makeup. And that always burns me up when I hear that. But oftentimes a jury can be swayed by that. I had a case once, thankfully, we were able to settle it, where a woman was on a business trip. She was a salesperson, and all the salespeople in the Eastern region had a big convention in somewhere in the East Coast, and all these salespeople came. It was supposed to be half fun and half work, and there were sales conferences and seminars during the day. And at night, they all went out to dinner, and they all went out drinking afterwards. And she was one of the few women, but she wanted to be part of the team and be a team player and show she wasn't a wet blanket. So she went out to dinner, and she had a few too many drinks, and she ended up being woozy and kind of passed out. And some of the men took her to her room and then had their way with her. And she, came to the next morning, and she was furious. And the employer, the lower level employer decision maker said, well, look, what in the hell do you think you were doing? You were drinking with these guys. Come on, you showed poor judgment. We were able to settle that case because the president of the company, we found out, was absolutely scandalized. And he should have been. He apologized to her, and we ended up settling. But this is, again, one of the things which women, I use women, it could be men. There are certain situations where men are the victims, but I'm going with the usual normative way of looking at things. How much do you want to be social and a team player? And does getting is drinking too much somehow a waiver of your right to integrity of your body? I mean, that's what the issue is, and this is one of the things that victims of bullying or harassment have to think about. The flip side of this are employees are too sensitive. They complain about little things. And again, I already told you about that. The courts are not real patient with people who complain about minor, low-level harassment. Oftentimes, it's hard to find witnesses because a lot of employees don't want to come forward because they're afraid for their own jobs. Very rare does someone come forward. The only way you can get someone really to come forward is to subpoena them for a deposition, where you can ask them questions which they have to answer under oath. But even then, oftentimes employees hedge their testimony to the best of their recollection, so forth and so on. So that's another one. Another one is, how much did you suffer emotionally? It's very hard. Your life becomes an open book, because once you ask for damages for sexual harassment or racial bullying or sexual bullying, your life becomes an open book. The employer can subpoena your Facebook account, and then he gets to see all the things you do in your private life. So if you have a busy social life and you happen to date a lot of guys and are socially intimate with a lot of guys, you can say, whoa, look at her. And boy, she couldn't have suffered that much. Look at what she does. Of course, you have a right to your own life. And just because you like to date a lot of guys doesn't mean you're willing to date anybody or be bullied by anybody. But that's a problem. I've seen situations where women have been devastatingly emotionally distressed, but there's a social media picture of them smiling at a family picnic. And you say, well, look at her. She's having a good time. She's smiling at a family picnic. All right, what does that mean? It just shows that on one particular snapshot in time, she was happy. I'm not saying this is, again, fatal to one's case. I'm just saying these cases are never, ever easy to go through. Plus the fact that it's expensive to go through these cases. You have to take time off of work to go to depositions. So while you have all the legal rights of recourse in the world, actualizing them is something else. Another, I'm about to wind up here because I want to leave room for questions, but it's hard to sue an employer that you still work for. If you haven't been fired, you're just suing to stop the harassment. Also, if you get a new job and you say, oh, by the way, I need to take time off next month because I have depositions to go to, your employer's going to want to know why, and ultimately he's going to find out. And if you file a lawsuit, a lot of employers, before they hire someone, are going to check in to see whether they are a complainer, a lawsuit filer, or an EEOC charge filer. All this is a matter of open record. So that's another thing which goes up against a potential plaintiff. Look, I'm not trying to say here that the whole legal structure is illusory. Obviously, it isn't. But it just takes a lot of gumption and a lot of dedication to seeing these cases through. And ultimately, most cases never make it to court anyway. They're settled. And so, at some point, you may be in line for a decent settlement. But even there, and this is, I'll leave you with this, the higher up you are on the food chain as a plaintiff, the more money you generally get in damages. If a waitress gets harassed and she suffers emotionally, the employer generally comes in with a lowball settlement and says, come on, Don, that's a lot of money for her. She's never seen that kind of money before. She'll probably take it. And frankly, she will. I mean, $10,000 or $20,000, $30,000. If a female surgeon at Children's Hospital gets sexually harassed, she's going to ask for a heck of a lot more money than that and generally get it. So again, the status of the employee does play into this a lot too, and that's just not fair. But fairness doesn't get you very far in this kind of business. Any event, that's where I'm going to leave off. Again, I'm not trying to be too pessimistic. I hate even talking about stuff like this, but it is the reality of the situation. So I hope I've covered everything, and I'm more than happy to take questions.
Thank you so much for presenting about your work and sharing some really enlightening stories. I'm gonna stop the share now. I put in the chat the document so that if you want to refer back to the document at any point, you have the PDF file there. We have a couple questions. One question is from Barry. It's a specific question about Hobby Lobby. The question is, does this mean that Hobby Lobby may not need to consider hiring a qualified gay candidate? Or can they fire an employee in good standing when they come out or reveal that they are gay?
Well, I mean, according to the Bostock case, the answer is no. But like I said earlier, there's another train coming around the bend, so to speak. And we won't know more about this until next year when the court decides if they're going to take a religious case. We all know what Hobby Lobby is. Hobby Lobby is the craft store where they already won a victory in the Supreme Court that said that it would be a violation of Hobby Lobby's religious freedom rights to force them to subsidize medical coverage for things like abortions or birth control pills or things like that. And I always thought that was wrongly decided, but that's the law. So the question becomes, should that extend to just passively having a gay accountant on the workforce? What is the gay accountant doing that's sinful other than coming to work? I can see where Hobby Lobby says it's sinful to use birth control pills. It's sinful to have an abortion, and if I have to pay money towards that, that I am violating my religious principles. Again, I get it. I don't agree with it, but that's the argument. But to say to someone, by paying a salary to someone who's gay, I'm violating my religious principles, I think that's a quantitative leap beyond what the law is. Now, I think the bigger question is if the gay individual has a same-sex spouse who wants family medical coverage. And then Hobby Lobby or somebody like that, and they say, well, wait a minute, now you're telling me I have to spend money to cover someone who's living in sin with someone else. I don't agree with that either, but that I think is more of a colorable argument than just saying, I don't want to hire gay people. This is going to come up. If it doesn't come up next year, probably the year after that. It's something to look at.
Okay, so that was actually the only question that we got in the chat. I do want to see if there are any other questions that have come up. So if you have a question, you can just wave your hand in front of the screen. Oh, Jeff Gushin has a question. Go ahead, Jeff.
It's not necessarily a question, but more of a comment. And I know you've talked about what happens in these cases and when they come forth. I think a significant part of what companies need to do, and one of the things that I did in my career was doing the prevention of harassment training. And I think oftentimes companies or people at companies, particularly in management, are unaware either of what the regulations, what the laws state. Sometimes they're unaware of what, or don't think about what the consequences are of not addressing harassment in the workplace. And I think it's extremely critical for those companies to really, and organizations, to really get the proper training so that people do understand. I think you talked very well, Don, about some of the nuances and how things can be sometimes misinterpreted or ignored, and the fact that companies do take that responsibility, and I think also recognizing how it's going to impact on their bottom line and also public opinion. So I think that's a big part of that's sort of the flip side, or the to be able to do it in such a way so that companies get the proper education, training, and focus on prevention.
Yeah, Jeff raised a very valid point that I should have talked about, but I don't want to paint all companies as dens of iniquity. I mean, a lot of companies are just trying to make money. And again, even if a company wins a sexual harassment case, they pay up to $100,000 in legal fees. And if they're a company which is in the a public eye, like a restaurant or a hotel or something, they're going to get a lot of bad publicity, even when you win. I mean, if you win saying, well, this was really bad, but it didn't rise to the level of getting damages assessed. Yes, I mean, a lot of companies, and it is a success when you stop fires from starting in the first place. Although I'm very cynical. I mean, you would think that by now people would stop doing this stuff, but they still do it. I mean, it just beggars the mind to know that no matter what, people think they can get away with stuff. But you're right. I mean, anytime you can stop it from happening, you're ahead of the game. That's a very valid point.
Yeah, I think one of the things that happens sometimes is when you particularly get down to mid-level management, is oftentimes people who get moved into management positions may not be as aware of what they need to do, or for a variety of reasons are uncomfortable in addressing when harassment comes up in the workplace. They sometimes may ignore it, they may turn the other way, they may try and the people who are reporting it, try and, as you said, try and appease them in some way, or just say that's the way things are, and don't know quite how to address it. And then it gets stuck at that level until things really get out of hand, before sometimes upper management or HR becomes aware of those situations.
A real problem is when the harasser is a rainmaker, a really big person, and you say, well, if we punish him or anything, we may lose him, and we may lose a lot of money that pays our salaries. Those are very, very tough cases. Good point, Jeff.
And I just want to make sure, Barb, I saw that you are unmuted. Did you have a question?
Am I unmuted?
You are unmuted, but it may have been an accident. I just wanted to make sure that you didn't have a question. All right, so one last check to see if there are any questions.
I have a question. Yeah, how is emotional distress calculated to get money? I mean, I don't understand how they could actually figure out how much under duress the person would be and how much they should get for it.
That's a good question. There's no way to quantify that. It's not like back pay where there's a formula. And it's an X factor. A lot of times plaintiffs put on expert witnesses like psychiatrists or social workers to whom the employee has treated. And the more fallout there has been, the more compelling her case is. But again, how do you put a number on that? And it varies from one part of the country to the other. I had a case once where a woman worked for a hotel, and they hired Jack the Ripper as the dining room manager because he was a good dining room manager, and they needed one because a convention was coming in, and they overlooked the fact that he had been fired from another job for sexual harassment. And this made my case more compelling. We got a pretty decent settlement with the judge's intervention. And the judge said that had this case been brought in New York or California, I would have gotten triple the amount of money that we get here. Because people, I'm not saying this is good or bad, but people in Southwest Ohio look at, like, say, $100,000 as a fortune of money, whereas in other parts of the country, that, a big deal, that's nothing. But you're right, Candy, there's no science to this. It's an art. And every case stands on its own principle. The more corroboration you have from other workers that she doesn't want to go to the movies with her friends anymore, she's snappish with her children. I mean, there are a million different things you can try and elicit. I guess the more you can show that quote, the more unquote money you can get. But yeah, and I think in this part of the country to get something over into six figures for emotional distress, it's possible. You can do it, but most cases are lower than that.
I have a question about this trying to show emotional distress. Once you put that out there, everybody can see that because it's public knowledge, correct? That you've seen a psychiatrist. And so, it depends on how much you want out there. Is there any privacy with that?
That's yeah. I mean, you can have, and sometimes both sides want to enter into something called a stipulated protective order, which says that all proceeds, all the transcripts of all the depositions, all the exhibits are deemed confidential within the litigation. It can't be shared with the outside world, and the court will put a seal on it if both sides want it. That still means that that the people in the litigation know about it, the lawyers, the court reporters, the witnesses, the secretaries, they all know it. But it does prevent it from seeping out into the outside world. And sometimes employers also want confidentiality because it's embarrassing for them too. They don't want all this stuff out there. So yeah, you can do that.
Okay, so that will have to have been our last question. If you have any more questions that you would really like to ask Don, you can either put them in the chat right now and I can send them to him, or you can email him directly. Don, would it be okay if I send out your email address if somebody asks for it?
Yes, that's fine. That's fine.
Okay.
You have it?
So if you have another question, feel free to email me and I'll get you in touch with Don.
May I make one comment? If you are interested in part 2 of bullying, my talk will be about that tomorrow. I purposely timed my presentation to come after Don's to see how close the animal world is. What our cousins who are this close to us are bullies as well, and maybe we.
I don't think there's a difference.
So far.
Okay, and then before we officially end, we're going to blow the shofar. Elaine, we haven't seen you yet. Would you be able to give us a tekiah call?
Oh, of course. Okay. Tekiah.
Thank you.
Okay.
All right, and with that, I will officially end our presentation. Thank you, Don, again for this wonderful, enlightening presentation. And hopefully we'll see you all tomorrow for Sandy Spitz's presentation.
Okay. Thank you.